The Supreme Court has announced it will take up a case next term that could potentially strip federal agencies of some of their powers. The case, Loper Enterprises versus Raimondo, seeks to overturn a nearly 40-year-old legal precedent known as Chevron deference. It directs courts to defer to federal agencies when interpreting unclear laws. The Chevron deference has been targeted by conservatives, and they believe it gives too much power to agencies and the executive branch. For more on this, let's bring in Jess Bravin. He's a Supreme Court reporter, correspondent for the Wall Street Journal, I should say. Jess, there's a two-step that was established, as I understand it, by the Chevron case that's at the center of this back in 1984, I think. What is that two-step process?
Well, it's very simple. It seems like almost too obvious. The opinion, a unanimous opinion by Justice John Paul Stevens, says first you see if this question has been quite specifically answered by the statute. Is it completely clear what Congress wants to happen? If the answer is yes, well, then courts have to enforce that. They don't have any discretion, and the agency has to obey it as well. But what if the statute is ambiguous? And of course, a lot of law, as you said before, is a bit ambiguous. If it is ambiguous, this decision said the way courts should behave is they should defer to a plausible interpretation by the agency. So that's the idea. The agency is the expert in this area. Congress has assigned it the job of carrying out its function. So courts should defer unless they're making a very implausible application of the law.
And is the practical tension here that on the one hand, in a complicated world with fast-moving and changing things, you want agencies to have some ability to apply a law to the changing environment. On the other hand, you don't want people who are not elected and not responsible to the voters making grave decisions that the voters have to then live by. Is that essentially the tension we're talking about here?
Well, yes, that's the tension. I mean, critics of this decision say that courts are too eager to find ambiguity and too ready to turn over the decision. So essentially, the challengers to this case, the industry, wants courts really to be more activist, if you will, to sort of step in and take this power to themselves that under the Chevron precedent, the agency lawyers decide. And behind it is really a great skepticism of what's called the regulatory state, that federal agencies just arrogate too much power to themselves. And this way, an industry that's challenging a regulation can get basically a second chance to fight it before the court, much as they are able to comment during the rulemaking process for a federal agency.
And so if the Supreme Court, well, let me step back before the court does anything. Why are people paying so much attention to this issue, given the current makeup of the court?
Well, this is one of the many other shoes to drop after we saw the court overturn Roe versus Wade. That obviously was number one on the conservative agenda, but there are many, many other errors that conservative legal thinkers believe the Supreme Court has made over the past decades, and this turned out to be one of them. Now, at the time, it actually was a victory for conservatives. There was environmentalists who challenged a rule by the Reagan-era EPA, led by Justice Gorsuch's mother at the time, Ann Gorsuch Burford. And the environmentalists said the agency had not followed the law properly. The Supreme Court said agency gets discretion if the law is ambiguous. But more recently, it's been industry that has been unhappy with the way that agencies are exercising their power, especially the EPA. And they're the ones who want to basically turn this power over to federal courts, where they think they'll have a more sympathetic ear than with regulators who might have devoted their lives to, say, pollution control, and they believe are overstepping their power to achieve those ends.
And so let's say, is turning over authority to the courts the only option here? Because couldn't the courts essentially say, you know, this is ambiguous, send it back to Congress, they represent the people, let them figure this out? Is that a possibility here? Or in reality, would it essentially be that courts would end up making these judgment calls?
Well, it's always a possibility for Congress to step in and rewrite a statute to clarify things if it believes either an agency or the courts have gotten it wrong. We're not talking about, provisions of the Constitution. These are all laws often environmental laws like the Endangered Species Act or the Clean Air Act. And so Congress can overrule either an agency or the courts by rewriting the statute. But how is it, how easy is it, I'd say, is it to pass something through Congress these days, right? I mean, can the Congress really pass anything other than renaming a post office? I mean, they have a lot of trouble finding consensus on many issues. And the idea that they would go back into the extremely detailed, complicated statutes that often are in play here, regulatory statutes that spell out a lot of specifics but leave others, to future developments, is a question. So essentially, Congress has been the least present actor when it comes to federal policy for for at least for a number of decades. And it's been the executive and the courts that have been making the decisions while Congress has been stalemated. This is a case that could reset that balance somewhat and turn over more discretion to the federal courts from the executive branch agencies.
Jess Bravin, thanks a million for being with us. We really appreciate you helping us understand this.
Anytime, John.